You have 8 in the room.
All right, I'd like to call the meeting of the Senate Courts of Justice Committee to order. Clerk will open the roll. I just did.
Senator Carol Foy,
Where'd she go?
Subramanian too. Mr. Chair, you have a quorum.
Thank you, MJ. Ladies and gentlemen, we're going to suspend for a second to just touch base with our Republican friends who are in caucus right now. Make sure that they're okay with us proceeding without them on this easy stuff at the beginning. So we're going to suspend for a second.
The Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia.
Assuming we knock these out, we'll have about 50 to go with either 2 or 3 meetings, depending on how it goes. So I think we're actually doing pretty well. First of all, Delegate Shin has requested that House Bill 926 go by for the day. Without objection, that bill will go by for the day. House Bill 457 by Delegate Carlson needs to be re-referred to Rehab and Social Services. Senator Deeds moves. Boysko seconds. The bill be re-referred to Rehab. Clerk will open the roll.
Ayes 8, no 0.
Great, thank you, MJ. All right, next up on the docket, we have identical uncontested cognates. We have House Bill 156 by Delegate Green, which is identical to Senate Bill 638 by Jordan.
So moved.
Hold on, we're going to do them in a block. We have House Bill 679 by Delegate Leftwich, which is identical to 386 by Deeds. We have House Bill 1242, which is identical to Senate Bill 546 by Bagby. We have House Bill 1388, which is identical to 201 by Diggs. All of these passed unanimously previously, and they're all identical. Senator Deeds moves and Boysko seconds that we report these in a block. Clerk will open the roll.
Ayes 8, no 0.
Thanks, MJ. Next up, we have House bills that are identical cognates that passed unanimously that need to be re-referred to Finance. The first is House Bill 18 by Delegate Helmer, which is identical to Senate Bill 7 by Senator Reeves. House Bill 1187 by Hodges, identical to Senate Bill 614 by Pillion, and House Bill 1195 by Hayes, which is identical to Senate Bill 273 by Subramaniam.
I move we report the bills and re-refer them to Finance.
Oh, it's contested. Okay, sorry. We're going to do House Bill 18 and 1187 in the block.
Okay, I'll move that we report the bills and re-refer them to finance.
Okay, so those two are in the blocks, been moved by Deeds, seconded by Bagby. Clerk will open the roll.
Ayes 8, no zero.
Okay. House Bill 1195 by Hayes is up next, but given that that is contested, I'm going to hold off on that till our colleagues get here so they can record their feelings. Next up, we have cognates which are similar and not identical. First up, we have House Bill 452 by Delegate Carlson, which has to do with first offenders for 251 dispositions, similar to Senate Bill 362 by Senator Eben. We need a motion to...
Mr. Chair, would it be appropriate to move to conform to 362?
Yes, House Courts Committee reported our bill as unamended. So Senator Deeds moves, Perry seconds to conform the bill. All of those in favor say aye. Aye. Anybody opposed? No.
I move to report the bill.
Say Deeds moves, Perry seconds, the bill be reported. Clerk will open the roll.
Ayes 9, no zero.
Next up, we have House Bill 1022 by Delegate Wilt regarding the universal licensure of law enforcement officers. Senator Diggs had Senate Bill 207. I need a motion to conform this.
I move to conform this bill to Senate Bill 207.
Second.
Okay. Deeds moves, Boysko and Perry second. All those in favor of conforming say aye. Aye. Anybody
I move to
opposed?
report the bill.
Okay, it's been moved. The bill be reported by Deeds, seconded by Perry. Clerk will open the roll.
Ayes 9, no zero.
All right. Folks, do we have any others that are not contested? I don't think so. I think all the others have red votes on them, right?
With 102, the Senate cognate 356 had an abstention.
Microphone, sir.
Oh, get on your microphone.
Mr. Chair, I was just saying, with
Senator
House Bill
Deeds.
102 is identical, similar to 356. There was not a negative vote on that bill. There was an abstention.
Yeah, I think we're safe to proceed on that one. So we're going to call it now House Bill 102 by Delegate Reeser, which is similar to Senate Bill 356 by Senator Perry. I think the differences have more to do with our budgets than they do with substance. So Senator Deeds moves, and I assume Perry seconds to conform the bill
Mr.
to
Chair.
Perry's. I got it. We got to conform it, and then we amend it, right? Okay. All those in favor of conforming say aye. Aye. Okay.
Move
Bill's
to
conform.
report.
Wait a minute. Wait. Hold on. Taylor has a technical amendment.
Thank you, Mr. Chair. There is one technical amendment to be made to the conformed substitute. It would just be striking language to make sure that there's not duplicate language covering misdemeanor probation violations. So it would be
Okay.
on line 66 after
I'll
jail.
move the technical amendment, Mr. Chair.
Okay. So Senator Deeds moves, Boysko seconds the technical amendment. All those in favor say aye. Aye. Anybody opposed? No.
I move
Okay.
to report and re-refer to finance.
Deeds moves, Boysko seconds, report and re-refer to finance. Clerk will open the roll.
Ayes 10, no zero.
All right, you're off to finance. Stanley, we got nothing but contested ones. Wait, you want to wait till your pals get here?
Yeah, they're on their way,
I know, yeah.
unless you trust me to vote for everything.
Nobody trusts you.
You didn't have to say that so loudly.
Nobody trusts us. 1246? Okay. That was unanimous? Okay, we're going to call up House Bill 1246 by Delegate Willett. This has to do with law enforcement training for people with autism spectrum disorder. It's identical to Senate Bill 547 by Bagby. It requires a conforming amendment. Senator Deeds moves, Boysko seconds. We conform the bill. All those in favor say aye. Aye. Anybody opposed? No?
Move to
Okay.
report as conformed.
It needs to go to finance. So Deeds moves and
Report
Boysko
and
seconds to
re-refer to
report
finance.
and re-refer to finance. Clerk will open the roll. That was unanimous before. All right.
Ayes
Good.
10, no zero.
Good. We got some more red votes have walked in the door. We can go back to where we were. So let's go back to House Bill 1195 by Delegate Hayes. This has to do with the waiting period for the purchase of firearms to 5 days. It's identical to Senate Bill 273 by Senator Subramaniam. I believe it was a party line vote. Senator Deeds moves and Boysko seconds that we report and re-refer this bill to finance. Clerk will open the roll.
Excuse me.
Oh, yeah.
Ayes 9, no
I
6.
don't want to disappoint you.
All right, bill reports and goes to finance. Next up, I have House Bill 78 by Delegate Watts. This was similar to Senate Bill 16 by Favola. And I need a motion to conform it to the Senate bill with one additional change. Can staff describe the one additional change that we haven't had in this committee before?
Yes, Mr. Chair, the only change is, and it's been passed out to the committee, it's in the packet, but if you're looking at the substitute on line 34, it just adds the language, the purpose of, so now it would read, no search warrant, subpoena, court order, or other process shall be issued, executed, or served for the purpose of the search and seizure or production of.
Sorry, what line are you on, Taylor?
Mr. Chair, if you're looking at the substitute, it would be on line 34. It's just that language, the purpose of, was added.
I'll move
Okay.
that language.
Okay, yeah, you already moved it, I think. So, all those in favor of the conforming amendment with the one additional change, say aye. Aye. Anybody opposed?
I'll move that we report the bill.
Does not need to go to finance. So Senator Deeds moves, Boyce goes seconds. The bill be reported as conformed and amended. Clerk will open the roll.
Ayes 9, no 6.
All right. Next up, we have House Bill 1396 by Delegate Hope. This has to do with clerks being able to open their offices instead of the circuit court judges pushing them around. It was similar to Senate Bill 736 by Senator McDougal. I'm told there's a substitute which resolves the conflicts between the clerks and OES, which will make them identical. Right, Senator McDougal?
I think we got
Okay.
some clerks.
Mr. Chair, that's correct.
Okay, McDougal moves and
Some clerks need to be pushed around.
Obenshain seconds that we conform this bill with that substitute. All those in favor say aye. Aye. Anybody opposed? No. Okay. This Peace in the Valley compromise is now before us and does not need to go to finance, so McDougal moves, Obenshain seconds, the bill will be reported. Clerk will open the roll.
Ayes 14, no 0, abstentions 1.
Okay, and the last one in the easy stuff is House Bill 857 by Delegate Hernandez. This has to do with limitations period on collecting fines, similar to Senate Bill 514 by Williams Graves. Senator Deeds moves, Boyce goes seconds to conform the House bill to the Senate bill. All those in favor say aye. Aye. Anybody opposed? No.
Report from there, report.
Re-refer.
report finance.
Okay, Boyd moves, sorry, Deeds moves, Boyce goes seconds, that the bill be reported and referred to finance. Clerk will open the roll.
Ayes 9, no 6.
All right. Now, for those of you following at home,
Skipped over 310
we did?
for a reason.
Oh, no, I scratched it out by mistake. Sorry. We have one more. Senator Deeds caught that one because it was his bill. House Bill 310 by Delegate Hope. This has to do with the maximum number of judges in each judicial circuit.
Move to
It-
report.
Mr. Chair, Mr. Chair, I
Yeah.
move to conform the bill to the bill that passed the Senate.
Deeds moves, Perry's seconds, Boyce go thirds, that we conform the bill. All those in favor of conforming, say aye. Aye. Anybody
No.
opposed? A couple loud no's over there. I don't think we need to go on the board. You guys agree? Okay.
Just the usual suspects.
So Deeds moves,
Moves to
Boyce goes
report.
seconds to report and re-refer the bill to finance. Clerk will open that roll.
My apologies. There we go.
Okay.
Ayes 13, noes 2.
Report.
You're against all those
Just,
two judges?
just go tell them to change your vote. We don't need to revote that. Okay, so.
Ayes
for those-
15.
It's probably going to be 9-6 when it's done. So what that leaves us, for those of you following at home, is a bunch of new bills that we have not seen before, and I believe that takes care of all the stuff that's identical or close or cognating like. Yeah, so now I'm going to go to the sign up where we have, let's see, Davis is first up. Delegate Davis, 1443. Is this your first trip to Senate courts?
It is my first trip.
All right, you got to tell us your favorite food.
Favorite food? Pizza.
Better be a meat.
All right. Yeah,
Thank you, Mr. Chair.
what's your favorite moonshine? Just kidding. I'm sure he does. All right, Delegate Davis, your bill has to do with prohibiting people from contacting jurors after trial to avoid intimidating them, right?
Yes, sir.
Okay.
Thank you, Mr. Chair.
Why don't you explain it to us?
I'd like to speak to House Bill 1443. 1443 will protect our jurors from being harassed or intimidated after they've sat on the jury and returned a verdict. This issue was brought to me by some of the circuit court judges. Where? Good. This issue was brought to me by some circuit court judges in one of the circuits I practice in, and after a criminal jury trial, the defendant, after he did his time, was able to look up his jurors that were on his jury, and then he was able to find their phone numbers, and he contacted them and upset them and scared them, and they were reluctant to sit on the jury. And after that, they told their friends and family, and then those people were reluctant to sit on a jury. So I think this is a necessary bill to protect our jurors, and I request that the bill be
Senator Deeds.
So the crux of it really is with the intent to harass or
intimidate.
And that's kind of in the eyes of the beholder, isn't it?
I think we have similar language in other statutes that similar language.
So, Mr. Chair,
Senator Deeds.
if a lawyer looks for jurors to find out what went wrong with their case or something,
That's perfectly allowed.
perfectly all right?
Yes, sir.
Mr. Chair, would you object to anything that allowed us to knowingly and intentionally contact and threaten? Or,
Yeah, so Delegate Davis, I think he's asking whether you want to add a threat in addition to just harass or intimidate. What do you think about that?
Is it intimidating? I mean, certainly if they threaten, absolutely that. But
All right, Senator Deeds, you got
I
that?
don't think it should be.
Counsel, where would
All
we stick
three.
a threat in the statute?
harass, intimidate, or threaten?
Yeah, make sure you talk to the chair. Senator.
I'm sorry, I apologize.
Counsel, you got that? Okay.
Mr. Chair, I'm sorry, I missed it. If someone doesn't
Sorry.
mind
Senator Deeds
repeating.
has suggested that we add a threat to this in addition to contact with the intent to harass.
Mr. Chair and Steve can maybe help along. Sometimes we would say no person shall knowingly, intentionally contact by threat to kill or do bodily injury with the intent to, or you could add it to the list of the intents, but
Well,
Senator Deeds.
The thing that I worry about with this statute, with this bill, is that you would chill the ability of lawyers or investigators or anyone after the fact to contact jurors and find out what happened.
I don't think this does that at all. I mean,
Mr.
we're
Delegate
there
Davis.
to talk to them. I've done that many times after a jury trial.
Well,
and
Senator
request them.
Deeds.
I apologize, Mr. Chair. That was just my concern, and I think if you added threaten or something in there to strengthen the language a little bit, to make clear that, so it's not a he said, she said in terms of who had the intent to harass or intimidate.
Okay, Senator Obenchain, you had something you want to say? Look like, no? Okay. Want to try and add it, or you want to take this by, or you want to do well, it's a little more complicated surgery than that, I think. Want to go by temporarily, see if we can come up with something? Okay, why don't we go by temporarily, try and come up with some words, and
Yes, sir.
maybe
Thank
you
you,
and Deeds
Chair.
can go in the corner with our lawyer and figure that out real quick. Okay? So next up, I have Delegate Martinez. Is he here? There he is. Oh, man, this one. House Bill 210, this is going to be a hot one. Delegate Martinez, you missed all the fun last time, and you also missed the fun 3 years ago. Yeah, we've seen this before. You're basically trying to put the Uniform Electronic Wills Act in the Virginia Code. And it was briefed by us by Senator Herring last week. Did you watch the video?
I watched everything.
Okay.
Yes, I did.
Anything else you want to say before we start asking questions or taking testimony?
Sure, Mr. Chair. I did watch the hearing last week, and before I start, I wanted to make sure that the text amendment that I added on line 402 or subtracted on line 402 was
Line amendment?
presented.
Yes, Mr. Chair. There's a line amendment. It should be in your packets. It's on line 402 after will, striking basically all the bracketed language, so the remainder of line 402 through death on line 403. And it's the language that's in brackets on those lines.
Okay, hold on. Still getting caught up, Sabrina. We're on 402,
Yes, Mr. Chair.
and the amendment is what?
So we're going to be striking after will on line 402 of a person domiciled out of the Commonwealth at the time of his death. And that was an amendment that was added, I believe, by the House Courts Committee.
Okay, and what does that do?
Mr. Chair, instead of, sorry, give me one moment. Instead of making this applicable to a person domiciled out of the Commonwealth, the limitations on the validity of other wills is actually going to be in the text starting on line 405. So notwithstanding the provisions of this, of the section for execution of wills, a will be valid as to personal and real property if the will is executed in compliance with the law of the jurisdiction where the testator is physically located when the will is executed, or where his domiciled or resides when the will is executed, or when the testator dies.
Okay, does somebody want to make that amendment to eliminate house language? Okay, Boysko moves and Senator Salim seconds the line amendment. All those in favor say aye. Anybody opposed? No. Okay. Anything else you want to say, Delegate?
Yes, as I begin to talk about the electronics wills bill, I want to answer a couple of issues that I heard while I was watching last week. Senator McDougal talked about a case that went to the Supreme Court, and a lot of it had to do with coercion. And I would have to say that that case was before there was internet and electronic meetings. So what I'm trying to say is that there is nothing that we can do to permanently prevent coercion. The second comment Senator Obershang made was that you'd be in favor if it was just for the military. But what ends up happening, you're forgetting about, for example, in my personal case, I have a father-in-law that's in assisted living in Tennessee who is a 26-year-old veteran who was a Vietnam-era veteran who was subjected to Agent Orange and had to go to San Diego every year to be evaluated. And there, anything we needed to do with electronic wills with a son in Atlanta, another son in Tennessee, and my wife in Leesburg, this would have provided a means where we all could conform to a will, and it would have been easier for us to do things in that manner. The other thing I wanted to say that is what this bill will do will allow us to do that, electronic wills, but I'm assuming that I can't walk into a Wills for Us and get a will in 30 minutes. It's going to take several meetings with my attorneys or clients' attorneys, and in those meetings, there should be a chance to detect any coercion if there is any. So, in that respect, this bill was made before COVID, but COVID has shown us that a whole paradigm shift in how we conduct meetings professionally is here, and it's not going to go away. and we need to find ways to get this done.
Yeah, so, hold on, Senator Deeds.
So, so when a person executes a will in this situation, is the notary public right there with them?
Yes, and
The notary public's online.
right.
Yeah.
What I will defer is to the stakeholders and subject matter experts on this. When I'm finished with the bill, I'm assuming you're going to.
So, Doug, I think the concern is not that people will go to a Wills for Us at a shopping center. They'll go to willsforus.com on a screen, and there'll be somebody on the other side of a screen, and there's not the human interpersonal facial contact, so you can't get the context of the room around to see if there's somebody on the other side of a camera coaching them on, telling them what to say. That's the concern that I think most of the people in the committee have. And I think the issue is that it's a balance between, do we want to make wills more available more cheaply to the broader public versus the balance of, do you make it easier for people to be taken advantage of or execute a will without the normal safeguards we have? That's the balance our committee is balancing. And do you have any thoughts about that?
Well, can I ask a subject matter expert to come up and explain
I'm sure
that?
they got plenty to say, but if you had any thoughts on that, that's kind of what we're really focused on. We'll get to testimony in favor or against
Okay.
if you want, unless anybody else has any questions for the patron.
Okay, so
All right, why don't we set it for 5 and 5 and go to people in support? And I know these folks have been lobbying us all week, and come on up and I'm sure
If
there'll
there's
be
anyone online
questions for
that
them,
would
I'm
like to
sure.
speak in favor, raise your hand.
Good afternoon, Mr. Chairman. Jared Calfee with AARP Virginia. I know the issue has been raised of the potential for coercion or for fraud. Obviously, that is something that AARP takes incredibly seriously as a potential issue with our members, but we do support this bill. The bill has been drafted in a way to ensure the integrity of the estate planning process and the documents that are drafted. I would point out that the Virginia version of this goes even a step beyond the uniform law in that it adds the requirement for an electronic notarization, which requires recording, which can later be gone back to if there are any potential issues. I'd also point out that in the states that have adopted this so far, we have not seen any evidence that electronic wills lead to any more coercion or problems than regular wills, which I acknowledge you cannot completely eliminate the risk of that, either with in-person or electronic wills. But the fact that around 60% of adults currently don't have a will is a huge problem. And so we view this as a solution that will make it more accessible and affordable for a lot of people. And that's why we support the bill. Thank you.
Thank you.
Mr. Chairman, Chris Nolan from Gar Woods here today in a personal capacity. I'm a Virginia commissioner to the Uniform Law Commission, which this bill is based on. And just to follow up on the comments that were made, this does go beyond the Uniform Act in requiring an electronic notary that, yes, is in the electronic presence of the testator and the two witnesses, which is defined in the bill. I would also point out that 13 jurisdictions have enacted some form of electronics will legislation. 7 of those are the Uniform Act. 4 were acts that were created before the Uniform Act. And then we have 2 jurisdictions, Puerto Rico and U.S. Virgin Islands as well. To be clear, an attorney in Virginia can access the provisions of this act. And the point of this is to put an electronic wills on the same footing as a physical will. And yes, we will concede during questioning that is there the potential for fraud to happen? Yes. Is there the potential of that today with a physical will? Yes, there is. Can I change the document itself by looking at the first word and the last word of a page and subbing in a different piece of paper? Yes, I can. At least with an electronic will, you have something that is locked down. You will know whether it has changed, and we have someone here who can speak to the process of the online version. I am not here on behalf of a vendor. I am here on behalf of the commission and would hope that you would pass this. And the final point, today I can go online and designate beneficiaries for my 401k, for my life insurance, for my IRA, and put all of those things outside of the estate. And guess what? There is no one there to see to make sure that I am doing that or someone else isn't doing it in my name. So hope you'll pass.
Mr. Nolan, I had a quick question based on your testimony. So,
Mr. Chairman, can we stop the clock though?
When we ask questions, we stop the clock.
Yep.
So you said that this somehow goes beyond the Uniform Act because it requires an electronic notary, but I was here and we did electronic notaries, I think it was 12 years ago. I was here and we did electronic notaries maybe 12 years ago.
Yep.
And an electronic notary is still electronic. They're still remote off in the internet land somewhere. So it's not really clear to me how an electronic notary helps resolve the things people are worried about here, that somebody on the other side of the screen from the testator is there exerting undue influence.
Mr. Chairman, you have a third party who has taken the oath of being a notary, who has a process to record. This has to be an audio-visual exchange to verify that the person is who that they say they are. And in the code, it sets forth, not in this bill, but in the electronic notary statutes, it sets forth the requirements of that electronic notary to verify the identity of the person. And I'm sure Will here can elucidate that even further.
Right, but a regular notary has to do that too. It's just an electronic notary is further removed than a regular notary, aren't they?
Except for the fact that you're going to have a recording of it in the electronic context.
Okay.
Because they have to go back.
Senator Stewart has a question for you.
I mean, I get what he's saying, but typically now if you're doing a will, you're recording that as well, just for proof later on. So that's sort of standard practice regardless, right?
Mr. Chairman, when I had my will done several years ago, that was not the case. I walked in, there were 2 witnesses that were paralegals that came in and witnessed it. And, I doubt they're going to remember that exchange, what I hope to be 30 years later here from when the time comes.
Mr. Chairman, I would advise the gentleman from McGuire Woods that that's pretty standard practice now to have a recording of that done, even with everybody present in the room. And it's very prudent measure as well.
Mr. Chairman, I would say I appreciate the gentleman's comment. I have the luxury of going to my attorney's office, okay? There are many people who do not have that luxury. I can go out to Walmart and buy a wills packet and fill that out and go take it to Grandma and have Grandma sign it, and that be the purported will. I can bring Grandma to your office, and I can make sure that she knows that she's riding home with me, and she better answer these questions correctly when she's sitting there in front of you. That happens today.
Senator, my Uncle Claude had his will done by Virgil Good and his 2 friends for $25 each about 30 years ago. I think times have changed, though. Senator Obenshain.
Yeah, Mr. Chairman, I would acknowledge that there are many opportunities for unscrupulous people to commit fraud and to unduly influence or coerce somebody into signing a will, and my concern is that we're just creating one more. And that is what I think we should not do. I think that there is a great advantage to having the testator and the witnesses actually sitting down with the lawyer and with the notary and with the witnesses for all of them to see all of the circumstances. And there are just certain things that should be done in the presence of the folks who are participating, and here you're introducing a lot of variables that you have no control over and no ability to assess, and that's my concern.
Isn't that true? Okay, that wasn't a question to you, Mr. Nolan. I think that was just a statement. So we need to.
I do understand the concern, and I'll just close with this, and because I do want Will to be able to speak. Last week, I got an email from a client unrelated to this, asking me for a referral for an attorney to do an estate plan and incorporation of a nonprofit. I thought it was for him. I wasn't sure. I said, "Do you want a referral in Northern Virginia?" I didn't offer anyone from my firm. He asked for someone who was reasonably priced. So I wanted to make sure that I was fitting the bill. And he said, yes, if possible, but not necessary. So much can be done virtually these days that I'm fine if someone was in Richmond area as well. I think it proves the point, right? There's an expectation from the consumer today that you can do this. And I understand the gentleman's concerns, and I cannot sit up here and say that it will never happen, right? It is possible that there could be fraud or undue influence. What we're saying is it's a balance.
Keeps using this as a moment to extend his argument, Senator Deeds. You want to ask me another question?
Your Honor.
Essentially, this would allow
sorry,
a testator sitting in Leesburg to deal with a lawyer sitting in Miami Beach and Notary Public sitting in Richmond.
Is that
Nobody's
right?
together at the time.
Electronic presence, people can either be physically to get some combination of physical or electronic presence. Electronic presence is defined in the bill to be visual and audio real time. So if you will allow, I believe Will here can explain how this actually works through a platform online for the companies that do it.
Okay, I think Senator Boysko has a question for you, Mr. Nolan, also.
Thank you. Could you give us some other examples of online ability to execute financial plans and wills? I know that I meet with my financial planner only on Zoom. He's in one location, I'm in another. We have secured signature kinds of things. I know that I've never sat down with anybody who executed my college savings fund for my kids. We did that all remotely. So I'm trying to understand if you can give us some more examples of how this has safely been done, because my parents live, in New Mexico and in Alabama, and this is very complicated. It will be very complicated for me to deal with some of this, and my own children don't live in this area.
Mr. Chairman, Senator, yes, I understand. And, I would say, again, you can go online today and probably dispose of the majority of your estate through electronic means without ever having to have it go through probate by designating your beneficiaries for IRAs, 401ks, 401(3)Bs, life insurance, and I'm sure there are some other examples as well. So we allow it in that context, and I would say in many cases the financial consequences of that are much greater than what we're talking about here. For someone who wants a very simple will to dispose of their estate when they die so that they do not die intestate.
All right.
These are typically very straightforward.
All right.
Mr. Chairman.
Okay, Mr. Nolan, you got 7 minutes at the mic.
Mr. Chairman, I
Senator
just
Stewart
wanted to
wants
ask
to
Mr.
extend this
Nolan.
further.
Mr. Nolan is so passionate about this, and he knows so much about it. And I'm a technological idiot and the first one to admit it, but I've been reading a lot about the progress in AI. And I understand that you can absolutely create an image of someone that appears to be that person, computer generated. Do you have provision, and their voices, do you have provisions in this software, or however it is you propose to do this, to guard against that?
Mr. Chairman, I cannot answer that question, but because I don't practice in this area with an online platform, but we do have a representative here, and I think also in the waiting room, who actually does this from a business perspective of being able to go online and do this. This is not the only way to utilize the act, though, right? You, as an attorney, could also purchase the platform that would allow you to see the participants, record it as well, and have a record of it, and to create the document and have an electronic signature related to it. But the electronic notary, which this requires, has to be satisfied that you are who you say you are, and there is, in a different code section, those notaries, there's a process for that. There are guidelines for that.
All right, Mr. Nolan, I think the question is about AI, which you said I don't know. So let's get back to the timer. We have 2 minutes and 5 seconds left for those in support. Let's see if we can wrap this part up.
Thank you. My name is Will Harnish, and I am with MetLife Legal Plans. I was an attorney for 8 years doing estate planning before joining MetLife Legal Plans. I am now in charge of the online digital product that they have. And I'm basically here to just talk about the process, what it actually looks like, how it functions. Basically, one of our members is able to go online and input similar to an estate planning questionnaire, where you get some basic information. A will is produced, and once the person has reviewed that will, they have the option in some of our states to go online and actually execute the thing. What this process looks like is they get signed up with an e-notary. The e-notary, we've talked about them, they verify the identity. And the way this is done, and this is how Virginia's laws are, is the notary gets an uploaded picture of the ID. So they see the face, they see the signature, and they see the verifying information. Once they're settled on that, it moves into knowledge-based authentication, which is required. They have to answer 4 out of 5 questions in 2 minutes. And those questions vary from list an address from the last 20 years, which car did you own, things that would be very difficult for just anybody to have access to. Once the notary is okay with all that, then they help the person pick what kind of signature they're going to do. Is it going to be on an electric pad? Is it going to be one of those preset ones that they can just stamp on? Once everything is all taken care of, the notary walks them through the process. The witnesses are there. They watch as the notary gives the oath for the will, has the person sign, the witnesses sign, and the notary stamps their certificate. This is different from what's required with physical wills in that there isn't that notary there to make sure everything is going as it should. That is time. Are there any questions?
Senator Obenshain has a question.
So I appreciate your description of the electronic verification process, the questions that they have to verify. Are you suggesting that the testator and each of the witnesses and the notary have to go through that process?
The testator would have to go through that process.
But not the witnesses?
The witnesses would have to show the notary through, whatever means that they are who they say they are. And in Virginia, they have their own ways of verifying that.
Mr. Chairman, further question.
One more question.
Where does it say that the testator has to go through that extensive electronic verification process? My experience has always been that all they have to do is hold up to the camera a driver's license, and that's it.
Thank you. Through the chair, it's in the Virginia code. I wish I had my computer.
E-notary code.
But in the notary code is where you'll find it.
Okay, great. All right, let's go. We have two online. Those online in support, we've already exceeded our time on the supporters. If you could just state who you are and state that you support the bill.
Juanita, you can unmute. Juanita, please unmute. Mitch Mitchell, you can unmute, and please make sure your camera's on.
Mitch Mitchell of Trust and Will, and I'm here in support of the bill, echo the comments of Mr. Nolan and Mr. Harnish.
Great. Thank you for being online. Okay, let's switch to opponents, reset the clock. Anybody here opposed to the bill?
If there's anyone online that would like to speak in opposition, raise your hand.
Anybody online opposed? All right. All right. Any further discussion from the committee?
Mr. Chair, I move that we report the bill.
Second.
It's been moved by Senator Boysko, seconded by Bagby, that we report the bill.
A substitute motion to pass the bill by, or continue the bill.
Carry over.
Carry it over the bill. Yeah.
Second.
Okay, it's been moved. The bill be carried over by Senator Obenshain, seconded by Deeds. And Stewart, we carry it over. That's the primary motion. We'll vote that first. Wow, look at that. Wow, what is that?
Ayes 7, no 7, abstentions 1.
All right, then we have to go to the primary motion to report the bill. Clerk will open the roll on that. Same result.
Ayes 7, no 7, abstentions 1.
All right, so delegate, you've got another, I guess, week to see if anybody wants to pull it off the table and do something with it. You're not dead yet.
Well, I want to thank you, and I may come to you for some help on how to figure it. How
yeah, and
to
this is
figure
a hot
this
one.
out.
This was hot 3 years ago, delegate, and it's still hot.
Okay.
All right.
And Mr. Chairman, FYI, my favorite food is chili dogs.
Welcome to the Courts Committee, Delegate Martinez. Okay, so next up, I have Delegate Ballard. 18 bills to go, guys.
Thank you, Mr. Chairman. This should be quick. I have House Bill 306. It was brought to me by the Virginia Indigent Defense Commission. That's a commission that my friend and colleague Senator Deeds sit on. And basically, this is not doing anything new. This is just clarifying that a conflict of interest exists when the public defender, with the concurrence of the executive director of the Virginia Indigent Defense Commission, determines that the active caseload creates a conflict of interest. And essentially, it prevents them from providing adequate representation. So we're adding that piece in the code to say that the public defender, where there are offices in Virginia served by the public defender's office, that that's a conflict and they can appoint court-appointed counsel.
Is there anybody opposed to the bill?
If there's anyone online that would like to speak in opposition, raise your hand.
Doesn't look like it. All right, it's been moved by Senator Deeds, seconded by Perry, I think, that the bill be reported. It's got to go to finance, so report re-refer to finance. Clerk will open the roll.
Ayes 15, no zero.
Bill reports refers to finance. Delegate Ballard.
Thank you, Mr. Chairman, members of the committee.
Say hi to Senator Lucas. All right, next up we got Williams. Delegate Williams, you have, let's see, you got a couple. You got 1248, 49. So let's do debtors interrogatories, which is a Boyd Graves bill, which used to trigger Senator Peterson when he was with us. What do you got?
Mr. Chair, I would like to pass by for the day 1248. The stakeholders have asked me to pass by for the day on that
All
one.
right, without objection, 1248 is by for the day. 1249, what do you got?
1249 is a pretty simple bill. It caps the cost and requires $250 within 60 days of an entry of an order if a plaintiff is a non-resident of Virginia, and this would only apply to court costs, and this is a bill recommendation of the Boyd Graves Conference.
Hey, Senator Obenchain has a question for you.
I don't have a question, but this is a great bill. I'd never heard of a suggestion of non-residency before, and I filed a will contest on behalf of a bunch of nieces and nephews who lived in Georgia against somebody, a bad guy. And he stepped up and filed a suggestion of non-residency and asked these nieces and nephews who didn't have two plugs nickels together to post a $30,000 bond apiece for in order to be able to file suit in Virginia. And it was a close call. So I think this is great. It needs to be capped.
All right. Is there anybody opposed to the bill?
If there's anyone online that would like to speak in opposition, raise your hand.
Nope. So Senator Obenchain moves, Deeds seconds that we report this Boyd Graves bill. Clerk will open the roll.
Ayes 15, no zero.
Bill reports unanimous.
Thank you, Mr. Chair and the committee.
See you later, Delegate Williams. We have next up Delegate Kent. Delegate Kent, is this your
Mr. Chair.
first? This is your second trip here, isn't it?
Yes, sir.
Okay, so you don't get to tell us your favorite food. Why don't you tell us?
Oysters and crabs.
Not bad. Okay. We should have asked you that the first time.
From the Northern
She's
Neck,
one of
if
those
I can
necks,
even
yeah.
use the location of the oysters and crabs.
Got it. So you got, this is not an oyster bill. Why don't you explain this grand larceny embezzlement bill?
Yes, sir. House Bill 1256. Thank you, Mr. Chair, for allowing me to present and consider this bill. As we all know, the venue of criminal prosecution typically relies where the offense occurred or where the defendant resides. However, we all certainly recognize in 2024 that there's a lot of things and crimes that are proliferated online by use of computers and phones. House Bill 1256 will allow specifically grand larceny and embezzlement cases to be prosecuted in any county or city where the victim resides if it cannot be determined where the crime was committed. This is especially hard to do in grand larceny and embezzlement cases where so many thefts are occurring online right now. It will close a loophole, as we've currently already done in legislation regarding credit card fraud. In addition, yes, sir.
Doug, I think you're probably in pretty good shape. Is there anybody who's opposed to the bill?
If there's anyone online that would like to oppose, raise your hand.
Mr. Chair, I'd like to know what the bill has to do with oysters and crabs.
We don't want any theft of any oysters or crabs. I do have someone here to speak in favor of the bill.
I don't think you're going to need that. Is there anybody opposed to the bill? Doesn't look like it. And our work group looked at this, didn't have any concerns, I think, right? Be cleaner to amend the larceny venue statute. No? I guess not. Okay, so is there a motion to report the bill?
Second.
Moved by Bagby, seconded by Obenchain to report the bill.
Mr. Chairman?
Yeah, Senator Perry, you have a question.
I just have a question. Whenever you said where the venue is, you said that you described it as there's a primary venue, right? You said only if we don't know where it occurred.
Correct.
I'm looking at the language, at least for what I have in front of me right here, and it doesn't seem to have that language in it unless I'm missing it. It
So
just says a prosecution for a violation of the section may be held in any place, a venue under Article 2, or any county or city where the victim of the larceny resides, or the embezzlement.
So it doesn't change existing code. So if you know where the crime has occurred, then it doesn't amend that. It just adds that if you
Right.
don't know.
Doug, I think the point is that it doesn't say which one's primary. It just says they can pick.
Oh.
And there is, Mr. Chairman, and there
Senator
is no
Perry.
primary determination in the criminal code as to one over the other. So I just want to clarify that I'm not entirely certain that that's accurate.
Yeah.
Okay, correct.
Okay.
It'd be similar to the credit card fraud code that was added also in where it allows it to occur.
Okay.
But it doesn't necessarily decipher which one comes first or second.
Okay.
Mr. Chairman.
Senator Stewart.
This came from our Commonwealth attorney in Westmoreland. She may want to
She's
share a
here.
specific example that happened if
Thank you.
necessary.
It's not clear to me it's necessary, unless somebody.
I thought it was in good shape.
Yeah. Yeah. Yep, okay. So Bagby moved and somebody seconded, Open Chain second that we,
Trying to figure out the oysters and crabs.
okay, Deeds is getting hungry. Clerk will open the roll.
Thank you,
Ayes
Mr. Chair.
15, no zero.
Okay, bill reports.
Thank you, Mr. Chair and committee. Thank you.
Okay, I'm going to cut off the list here really quick and hop over to Delegate Hayes, who needs to get up to approps, because I hear they get very weird when people aren't there.
Yes, sir. Demanding.
Huh? Oh, yeah, we already covered you.
Oh,
We already
we-
did you. You were one of the identical cognates.
Yes.
Yeah.
All right. Thank you all so much.
You want us
Thank
to
you, Mr.
you
Chairman.
want us to debate it? No? Okay. All right. So, next up, we have Delegate Walker. He just walks in because his staff signed him up. While all these people wait, you're on
I
that
hear you
list.
like to keep it short and sweet, Mr. Chairman.
You have, 331, which is a conveyance of an easement.
Yes, sir. On our side, they liked it very well. All this is just an access road to a property that a church in Lynchburg has purchased. Access to a tower. The
And
state
Doug Walker,
police-
is this in your district?
Yes, sir.
Is there anybody who's opposed to it?
No, sir. Nobody was opposed to it.
And it's a formality we have to do in order to do these kinds of things. This is a formality we have to do these kinds of things, right? Okay.
Yes, sir.
Okay, Senator Stewart moves, and I think Stanley mumbled a second that we report the bill. Clerk will open the roll.
I like you guys. Thank you very much.
I gotta go to approps too, yeah, at some point. All right. We done yet?
Ayes 13, no zero.
Okay. Next up, we got Delegate Leftwich. Is he here? I didn't see him. No Leftwich. So then we will go to Cousins. I haven't seen her yet either. Oh, we did Leftwich already? He can be taken off the list. Okay. Next up, I got Helmer, who we already did. And then I got Tran. I saw Tran. Okay. 986. You're trying to, I think, increase notary fees?
Senator Sorvel, the notary fees have not, yes, good afternoon, and thank you for the opportunity. The notary fees have not been increased in nearly, since the mid-90s. And so this will give notaries an opportunity to increase their fees up to $10 from $5. They don't have to, but many will continue, I assume, to not charge, but for those that need to increase their fees, they have that opportunity to do so.
So this is a 100% increase in notary fees.
It's been nearly 20 years, 25 years, yes, maybe, when you put it that way.
Yeah, okay. Anybody else have any questions for Delegate Tran? Nobody has any questions. Is there anybody opposed to the bill out there in the hinterlands?
If there's anyone online that would like to speak in opposition, raise your hand.
Okay, Bagby moves. It's Perry seconds that we report the bill. Clerk will open the roll. Yeah, we're not getting a lot of...
Ayes 15, no zero.
We did the hard one first.
Thank you so much.
Thank you, Delegate Tran. Okay, next I have, no Cousins, I got, oh, she made it. Okay, Delegate Cousins. And after that, just so people can plan, I've got Price, Rasul, Carlson, Glass, and Seabold.
Okay, thank you, Mr. Chair, members of the committee.
Cousins, you've got 824, right?
Yes.
All right. So, didn't we? Council, didn't we have a version of this before? Or am I imagining things? Yeah, didn't Deeds have this?
Mr. Chair, Senator Deeds' bill was discretionary and would have allowed courts to waive any or part of any cost or fine. I
Right,
believe
so
this
Deeds
bill
was
is different.
discretionary, this one's mandatory. Deeds, I think, got carried over when it got to finance, is that right?
I think that's correct, Mr. Chair. And I will also note, if everyone's just looking at the substitute that came over, which Delegate Cousins may talk about, but now the bill appears to just provide that if the court-appointed counsel fees are increased, then any increase is not going to go towards what's assessed towards the defendant. So it is a bit different.
That's right. The original bill would have eliminated.
I got it. So you're
Okay,
trying to avoid the fiscal impact by saying only the increased amount is waived?
Yes, yeah.
Okay, well, we'll see what Senator Lucas has to say about that, I think. Is there anybody opposed to the bill?
If there's anyone online that would like
Okay,
to speak in
folks,
opposition, raise your
This needs to go
hand.
to finance, so yeah, I got it. Everybody down there moves the report and refer to finance and seconds it too. Any discussion? No discussion? Okay. Clerk will open the roll. We'll see what finance staff says. I tried last time.
Senator Subramaniam? Ayes 10, noes 5.
Thank you.
See you later, Delegate Cousins. Next up, I have Delegate Price, who has 2, I think. You want to do 611 first?
Mr. Chair and members, there is a federal level Deaths in Custody Reporting Act, but as the GAO reports, the DOJ has yet to make an implementation plan for that. So despite being reauthorized about 10 years ago, there does not exist a place where we have a full list of all deaths that have happened in custody with pertinent information about the deaths, which prevents us as legislators from having a big picture on deaths in custody. So instead of waiting for the feds to get their act together, House Bill 611 would establish that, having DCJS to compile information from all local, regional, state, and juvenile facilities, from all LEOs to report any deaths that occur while in custody, which includes anyone who is detained under arrest, in the process of being arrested, en route to being incarcerated or incarcerated, and then they would analyze that data. We've been finding that most of the information that we do get is from journalists, but they even have hurdles, even through the information that they're seeking through FOIA. And it's also been shown that in states that require this information, the rate of suicides and homicides for those in custody have declined. And so that's the bill, and I hope you look favorably upon it.
Thank you, Delegate. Council, do you guys have some questions about this?
It's probably my next one.
Or have those been resolved? No? Memo I got says there's some questions, no? All right.
I was going to say the original bill did have a provision that would kind of oversee, but we took that out through a line amendment, and it's just recommendations within the report.
Okay, but this only involves death, but I know that there's some reporting that's already done by some agencies about
It's some deaths under-
shootings that result in deaths or serious bodily injury.
And then there are some deaths, I'm sorry, Mr. Chair.
Yeah.
There are some deaths that are also up to subjectivity on whether or not they get reported. So this would make it clear all deaths, all facilities within these custody or on the way to being incarcerated or incarcerated.
Okay. Does anybody else have any questions for Delegate Price? No. Okay, is there anybody opposed to the bill?
Is anyone online opposed?
Doesn't look like it. Okay, it's been moved and, yes, it does. Been moved and seconded by Carol Foy and was it Perry? that the bill would be reported and re-referred to finance. Clerk will open the roll.
Ayes 15, no zero.
Okay, the next up you you reported and off to finance. 614.
Thank you, Mr.
Community
Chairman.
service in lieu of fines and costs.
Thank you, Mr. Chairman.
And this has to go to, sorry, this has to go to finance also. Go for it.
As you know, prior to July 2020, only community service and work that was performed before and after incarceration was eligible in offsetting court fees and fines. And we passed House Bill 277 that allowed for community service during incarceration to count as well. And we defined what community service was. Our intent was for those that were incarcerated to be able to apply that so that they could pay down their fees and fines. Since then, we have heard from all across the state that this is being done in, I guess, against kind of the intent of the bill, but it pretty much depends on where you live, on what access you have to this. And so what the bill in front of you would do is clarify the language to better match the intent of the previous legislation, and it does that in a few ways while also expanding the program.
Delegate, I think a bill that was similar to this passed last year by Senator Boysko, 9-6, in the Senate 2218, but it died in the House. Is that right?
No, this is a bill that I've been working on. I don't know that
You
it's
didn't do it
ever had
last year?
No. Well, I
Okay.
did, but it wasn't. It did not have a Senate cognate.
Okay. Okay. Keep on going then.
Okay. So it would allow, as I said, it would allow work in traditional community service to help offset court debt. Clearly articulates that the work while incarcerated or community service hours can be completed within the detention facility or off grounds, and it would ensure that the people incarcerated in the DOC facilities and local and regional jails can avail themselves of this, and also require for the exact amount of the fines and fees and the exact amount of the hours worked to be communicated to the person so that they know exactly what they have to count toward offsetting the fines and fees.
Got it. So it's basically an expansion of existing policy, but it just...
And also clarification, like I said, there was a AG opinion that came out about community service. This would help clarify any of that miscommunication.
Okay. Anybody else have questions for Delegate Price? Okay, is there anybody who's opposed to the bill?
If there's anyone online who's opposed, raise your hand.
DOC, Vaca, nobody? Okay, Boysko moves, Perry seconds. The bill be reported and referred to finance. Clerk will open the roll.
Ayes 10, noes 5.
Thank you, Mr. Chair.
See Delegate Price. All right, Rasul is probably off in approps. Oh, Subramanian has a motion.
Thank you, Mr. Chair. I move that having voted on the prevailing side vote by which we did not pass HB 210.
He didn't.
Reconsider that vote.
He didn't vote.
Yeah, he abstained. Right, but he could change his vote to no and then vote. You could change your vote to no and then reconsider.
Okay, I'll do that.
Okay, he does that.
So no.
Okay. So code him as a red vote, and then he's
His
moved
vote
to
will be noted,
reconsider.
sir.
He moves to reconsider, so I guess that's a recorded vote, right?
Yes, sir. What bill was that?
Mm-hmm. Can you open the roll there? Got it. All right. So we're reconsidering.
Ayes 15, no 0.
All right. Is there another motion?
Move to report the bill.
Second.
Okay, Senator Subramanian moves, Bagby seconds. The bill will be reported. Clerk will open the roll. No. No. Yes.
Ayes 8, no 7.
All the lawyers vote no except one, and everybody else votes yes. Oh, no, sorry, two lawyers vote yes. Okay. All right. Doug Martinez, get ready for a floor fight on that. All right. So, back to the roll here. Is Rasul back yet? No. All right, so now I got Glass, Seabold, Cherry, Hodges, Green. Glass, you've got 250.
Yes, Mr. Chair. House Bill 250 is a bill to establish a comprehensive framework for custodial and non-custodial interrogations of adults and juvenile.
Can you lower that mic? There you go.
It asks, is that better?
Yeah, having a hard time
Got it.
hearing you.
Okay,
Yeah.
so House Bill 250 is a bill to establish a comprehensive framework for custodial and non-custodial interrogations of youth and juveniles and adults. It includes model policies, procedures, and standards of training. All it is asking DCJS to tell us what they believe is acceptable, unacceptable as it pertains to inauthentic record documents, statements, misleading statements, or statements of witnesses and co-conspirators. It does not provide any regulatory framework. It's just for us to really start having a conversation in the future about where they stand with custodial and non-custodial interrogations. The bill does have a fiscal impact. That FISC is to allow for DCJS to have a consultant, one-time allotment of them to be able to have a consultant come on and help them develop their model policies.
Okay, so Doug, we looked at this earlier. I think one of the questions was if the concern is about law enforcement officers using misleading statement and false promises of leniency or false statements about what the evidence is in connection with a custodial interrogation. Why wouldn't the better policy be just to create an exclusionary rule if police lie during the interrogation or mislead somebody in the interrogation instead of having a policy about it?
If I understand your question correctly, you said, why wouldn't it be an exclusionary bill?
Right, that's
to
the bill
just
we passed
outlaw.
before out of this body. As opposed to a policy about it, we actually passed a law saying if you use misleading statements in interrogation and you say there's evidence that doesn't exist or you say somebody confessed when they didn't, and then especially to a juvenile.
Copy. Well, part of that, Mr. Chair, is because over the past 3 years when we've been having conversations with both law enforcement and different departments, the mindset was there's certain things were perfectly acceptable in one department and not acceptable in another. And then we talk to DCJS and they say, well, that's bad practice. So what we're asking DCJS to do is on record say what they believe is appropriate and inappropriate. We can't sort of legislate police culture. That's the police chief's role and job. But we are trying to say, get it to a point where we are able to have real conversations about how technology is going in policing and how it's being used, and specifically the use of faith documents. And that's kind of the precipice of the bill, was the use of a faith document.
Okay, not a bad answer.
Sorry.
Any other questions for Delegate Glass? No? Okay. Is there anybody who's opposed to this bill to create a policy?
If there's anyone online that wants to speak in opposition, raise your hand.
Okay, nobody's opposed to it. I assume there's some people in favor. Anybody other questions for Delegate Glass? No? Okay, and let's see, does this have to go to finance?
Yes, sir.
Okay, Carol Foy moves and Aird seconds. The bill be reported and re-referred to, Senator Aird, that this bill be referred to Senator Lucas. Clerk will open the roll.
Ayes 9, no 6.
Got it too, Mr. Chair.
Yep. Thank you, Delegate Glass. All right. Next up, I have Rasul is still not here, so it's Seabold.
Thank you, Mr. Chair. HB 161 extends Virginia's safe harbor protections to people who are incarcerated. Last summer, we saw a rash of incarcerated overdose deaths, including 3 deaths over just 2 days at Greensville Correctional Facility. It's really important that we pass legislation like that because those who are experiencing an overdose while they're in a correctional facility need to be able to report it to staff without fear of being re-prosecuted or face strict internal disciplinary procedures such as solitary confinement or loss of privileges. So I would ask the committee to consider this bill, please.
So you're basically just saying that the safe harbor that presently exists for reporting an overdose when you're outside of jail also applies to people who are incarcerated?
Yes, Mr. Chair.
Okay. All right. Is there anybody, I'm sure there's people in support of the bill.
If there's anyone online that would
I'd
like
like to hear if there's
speak
anybody in opposed
favor of the
to
bill.
it first, though. Yes. You're opposed? Okay, come on up if you're opposed. Why don't we set it at, I don't know, how many we got left? Let's set it at 3 and 3.
Good afternoon, Mr. Chair, members of the committee. Elizabeth Hobbs with the Virginia Sheriff's Association. We are concerned about this bill, certainly understand the important need to protect folks who are overdosing and encourage people to seek care for that. But there are unintended consequences, I think, with this particular provision and applying a safe harbor provision that works on the street to an incarcerated facility where people are there who are exposed, perhaps involuntarily, to illegal narcotics such as fentanyl that has a broad-ranging impact beyond the person who is intentionally using it. And those people are captive to this exposure. And so providing, removing the incentive to comply with the law is endangering the people who are nearby, for sure. And it certainly impacts the safety of a jail and ability to keep the inmates safe and removing all of the disciplinary and administrative processes that's part of the bill.
So how does this remove the incentive to comply with the law if the only time it applies is if somebody overdoses? I mean, you're saying that somebody might use drugs assuming somebody next to them is going to overdose?
If the penalty exists to incentivize compliance, and if you remove the penalty, you remove the incentive. Sheriff Joe Barron from the city of Norfolk is here to additionally explain as a person who runs a sizable jail. I would defer to him.
Okay, let's go back to the clock. Come on up, Sheriff.
Thank you, sir. Listen, I'm here in opposition to this bill for a number of reasons. One, none of the stakeholders who are ultimately responsible for the life, health, and safety of inmates who are incarcerated have been included in the discussion as it relates to this bill and how it may affect or impact our operations. Two, to answer your question as it relates to someone who's having an overdose, it's not just purely the overdose itself that becomes a problem. It's the fact that the drugs got into the facility to begin with. How did they get into the facility? Taking away levels of accountability related to someone's actions of, how taking drugs and to the point of an overdose. It takes away our ability to investigate those things and try to track down how they got in there, whether it got in through staff, contractors, nursing staff, whether it was secreted, any of those ways. Accountability is leverage in the law enforcement community, especially when you're talking about jail operations. I pose it, one, because stakeholders haven't been asked about this, and two, has there been an increase in overdoses in jail facilities? Yes, but have they been studied to the point to where any of those drug overdoses would have been in a position where they would not have been able to otherwise report? I have much more to say, but I'll leave it if you have any questions.
Mr. Chairman. Mr. Chairman, asked the witness. The way I read this, so if there is an incarcerated person,
yes,
who purchases, possesses, or consumes drugs or alcohol,
well, it's only possesses for, it's consumes, possesses, or purchases related to things like marijuana and alcohol, but some controlled substances.
So my question is, so this
Stanley.
Thank you, Mr. Chairman. So this person who's incarcerated gets somebody to bring in the drug somehow, which is a crime.
Yes.
Consumption being a crime inside the prison.
Yes.
But then cannot be charged with any of those crimes if that incarcerated person, in good faith, seeks emergency medical attention or for himself or anyone else.
Right.
From
You
an
can't
overdose.
arrest them. You can't prosecute them. You can't perform any kind of disciplinary action. You can't take any administrative actions. And when you consider administrative actions, part of an administrative action is an investigation into how the drugs got into your facility to begin with and into the custody of that person. That becomes extremely problematic when I'm the one that's responsible for the life, health, and safety of the person or the people who are left in our care. I have over 700 inmates. I had overdose of inmate last year. Our ability to leverage, the fact that he was in possession. One, he was never charged, but that was the discretionary. But that led to our identifying how the drugs got into our facility to begin with, and our ability to change processes so drugs couldn't get in that way. So I hope that answers your question.
Mr. Chairman.
Okay.
And just
Senator Stanley.
Thank you. And so, it seems to me that incarcerated person, hypothetically, if they're able to secrete drugs and obtain them into jail in enough quantity, would want to have one of his buddies overdose every time.
Yes.
Is that far-fetched? Or, because that way he avoids trouble and everybody else with him
If I can answer that question.
Please, that's a question.
Right now, out on the streets, what we are seeing because of the safe harbor law, which I agree with and I think should be in place, is we have repeat offenders. And what happens is there's a process that occurs. The people, they they abuse the substance to a point of overdose. And when they have the overdose, they self-report. We have law enforcement or the fire department. We have emergency services respond. They hit them with Narcan. They revive them. Then they say they don't want to go to the hospital, and then they're put back on the street. Within hours or maybe days, the same process starts all over again with that person. What we don't need is for that process to be occurring inside of our jails or inside of our prisons.
Thank you, Mr. Chairman.
Senator Stanley. So, Senator Carol Foy, you got a question for this speaker?
Yes, Mr. Chair.
Okay, go ahead.
So I guess my question is, how many overdoses have there been at in the facilities?
Well, last year we had one overdose of a inmate. We had one overdose of a staff member who was exposed to fentanyl, who almost died on us, except we had Narcan and we were able to respond. We had an overdose in the lobby of a citizen who came to the public safety building, who had to be hit 4 times with Narcan before we can get them revived. His wife expressed the same thing, the same scenario, that he's a repeat offender. He's always doing this, always having an overdose, and then they come and they hit him with Narcan and he gets revived. Is it a problem? Absolutely. That's why we have substance abuse programs. But inside a jail facility, we have to be able to investigate. We have to be able to get to the bottom and the root of how things are getting into our facility. And also, if we're encouraging in any way, and not having some form of deterrence through accountability, then we're creating an environment where other people could be exposed, like my deputy was last year, to fentanyl and things like that, where just pure exposure can cause a death.
Senator Carol Foy.
Nothing in this bill will prevent you from investigating how the drugs got into the jail. Is that correct?
No. What the bill does is it takes away leverage that could be used through either accountability through prosecution, accountability through administrative wise or disciplinary purposes. That leverage, listen, I'm a long-time investigator, homicide, robberies, the whole 9 line. That kind of leverage, gets people to talk to you and say, "Oh, I'll tell you I'll tell you where I got it," that kind of thing, which is really the bottom line, what we're really interested in, more than prosecuting the person who's already in our jail. So it does take away some of the leverage all the leverage that we have to be able to get to the bottom of things.
Mr. Chairman?
Senator Carol Foy.
So is it correct to say that the leverage you're speaking of is the threat of charging them with a crime? Is that the leverage that you're speaking of, sir?
Well, it's the threat of prosecution. It's the threat of disciplinary action. Yeah, that's leverage. It certainly is. And it is the leverage that led to us last year of discovering that we were getting fentanyl and other drugs brought into our facility through Amazon packaging of the delivery of books to our facility. We changed our entire process at the Norfolk City Jail on how books are delivered. And so we don't let parents or friends or loved ones send books directly to the Norfolk City Jail anymore. And, through our intelligence, listening to phone calls, We know that drug supplies in the Norfolk City Jail have dried up as a result. So that's a good thing. Our jail is safer as a result of that. But without that information, and that person was never charged. We never charged that person. The goal is the life, health, and safety of our facility. Not so much looking for other means to charge people and keep them in our facility. Our job is really just trying to create a safe environment. But again, the stakeholders, sheriffs, superintendents, we were never asked about this. We were never asked about how it would impact our operations or our ability to do our jobs and to create that environment.
All right. You done? Senator Bagby, you got a question?
Yes. Help me understand this. Mr. Chair, if I had a problem with heroin.
Yes.
And I came to someone at the facility and asked for help.
Yes.
And oh, by the way, here's some heroin that I have.
Yeah.
How would the gentleman respond?
So I would support a bill where somewhere up front.
No.
Yeah,
No,
but my
no.
response is that.
Mr. Chair, Mr. Chair, I would ask the gentleman, how would he respond?
How would I respond?
How would the facility respond?
We would take the drugs, we would dispose of the drugs, and, we'd appreciate that, he was upfront about that, because he's trying to kick a habit. And we have all kinds of programs related to substance abuse and getting people on the right track. Our job is to make a difference. Our job is try to help people, that when they leave our facility, they leave in better footing, not in worse footing than when they came to us. So that's part. And there was this idea of, having, when people were brought into our custody, some kind of thing said, look, if you have any drugs on you, you're not going to be charged. Toss them in here. Don't bring them into our jail. Because the jail facility, that confined facility where we have people as many as us right here all living in close quarters to each other, that's my greatest concern, of everyone's life, health, and safety, not just the individuals. I care about both, but I care about it all. So I want those drugs not to come into my facility, and I would support anything that would allow me to bring, say, put them over here in this bin, and we will turn a blind eye to it. We don't care about that. We just don't want it into our, brought into our facility. And I hope that answers your question.
Senator Bagby, you got another question?
I would just ask the patron to restate what the intention of the bill is.
She probably has some responses to everything that was just said too, but we're not quite there yet.
Can I respond to the sheriff?
That was my question, to restate I think we need to put it back where.
Hold on.
Mr. Chair?
Yeah, Senator Bagby.
That was my question.
Okay, hold on. So right now we are in people opposed. We have 12 seconds left. I'd like to go and finish the opponents. Then we can go to the people in support. Then you can answer, clean up whatever needs to be cleaned up.
Thank you, Mr.
And
Chair.
then we'll go from there. That's what we'll do. Is there anybody else opposed with the 12 seconds left? Anybody online?
Fatima, you may unmute and please make sure your camera's on.
You have 12 seconds.
I'm not opposed.
She's a supporter, I think. Okay. All right. I'm sorry. She said, okay, I'm sorry. She said she's opposed. She's not opposed. Okay. All right. So why don't we reset the timer and get the supporters?
Mr. Chair, may I respond to the sheriff's?
After we do the support, and then you can clean up. Okay. Well, Senator Bagby really wants you to respond. So why don't you? Well, the supporters will probably answer a lot of it, but go ahead.
Mr. Chair, and thank you, Senator Bagby, for the question. My intention of this bill is to keep people alive, and that is the sheriff said his greatest concern is, making sure his facility is running. But my response to the sheriff should be that his greatest concern and the low-hanging fruit of his job is to make sure that we're keeping people alive. And if we're putting barriers up to reporting overdoses, and if someone's reporting an overdose, they are on their way out, and we have ways to treat people, and we have easy ways to treat people, and we should encourage those people perhaps people that they are out in the courtyard with, or people who they are in a cell with to report that. And we should not put up any obstacles, because our job as legislators and our job as supervisors in these facilities is to keep people alive. And that should be our priority. And just to clarify a few other things that he said, the Department of Corrections Director, Chadwick Dodson, has admitted that staff is bringing drugs into our correctional facilities. That's the number one way that drugs are getting into facilities. So if we're not able to keep our staff from bringing those drugs, then we should at the very minimum make sure that we're keeping them alive and not creating obstacles. We did ask the Sheriff's Association that for their feedback, and in fact, if you look at the history of this bill, there is a substitute. The original bill, if you look at that, included not allowing evidence as part of the incentive to report overdoses. And so as a compromise with DOC and with the Sheriff's Association, we removed that piece. So they are more than welcome to gather evidence as a result of this overdose. So that is false. And also just one more response to Senator Carol Foy. There was 32 overdose deaths in the last 4 years in just our jails alone. And those are the ones that are reported. So there is a lot that's happening that was unreported. And if you don't mind, Mr. Chair, I'll step aside and let the supporters speak.
Okay, let's reset.
Can I ask one question?
Question to the patron, Senator Stewart.
And I think I
8
understand
bills
the
left
bill,
to go.
but I want to make sure that I understand it. So given the way your bill is drafted, and if you sell those drugs, give them whatever, and the person has an overdose and you report it, you can't be prosecuted. Is that true if the person dies as well? The person dies from the overdose, as long as you make some effort to report it, you cannot be prosecuted. Would that be true under your bill?
I'm sorry, Mr. Chair, I'm not understanding if the person's
If you
dead.
make an effort to
Senator
report,
Stewart, I think with Senator Stewart's, we've had some murder fentanyl cases going on.
Oh.
Just ask.
Statutes. So, for example, I think what he's saying is, suppose the person who reported the fentanyl was like sitting right next to him, put the pill in their mouth or something, and then the person overdoses. Now the person calls the overdose. Normally they could be charged with felony homicide. Senator Stewart wants to know if that person would then not be capable of being charged because of your bill.
They will not, yes, they would not, if they're reporting an overdose, they will not be charged.
So they could,
Senator Stewart.
They could avail themselves of this safe harbor provision.
Correct. Our goal is to keep the person overdosing alive. However, Mr. Chair and Senator Stewart, the facility is allowed to use the evidence collected from that report. So if that leads to additional information on where the fentanyl came from, then that is allowed, because that was part of the substitute that we offered.
Delegate, I think council has a different answer than the one you gave and the one I gave. So, Taylor, why don't you fill us in?
Yes, Mr. Chair. I just wanted to note that the bill only protects you from being arrested, prosecuted, or from disciplinary action related to the specific crimes and statutes that are listed. So just for unlawful possession alcohol, unlawful possession marijuana, possession of controlled substance, any of those that are listed. So those are the only statutes that it provides.
So it wouldn't apply to felony homicide or something like that? Yeah. Okay. Supporters, reset the timer. Get close to the podium. Come on. What was it? Was it 5 or 3? I think, was it 5? Come on up.
Good morning. Good afternoon. Thank you very much, Mr. Chair, members of the committee. Taj Manheft, Director of the Humanization Project. I would just like to say that this is not about anything more than keeping people alive. I have personally seen and witnessed when people by the hundreds will ignore somebody dying because they are afraid of getting in trouble. If you simply report the matter, you will yourself be put under investigation and put into solitary confinement. That is not the way we keep human beings alive, and that is the priority here. Thank you.
Thanks. Come on up.
Good afternoon. Sean Moneta speaking on behalf of the ACLU of Virginia. Wanted to point just to a couple things. First off, I'll point to some numbers from the Department of Corrections. In the last fiscal year, there were 231 Narcan deployments where Narcan was actually used. 98 of those were suspected overdoses. That's just in the fiscal year of the last fiscal year. Obviously, those of you on the committee know that I spent 16 years in prison. I'll point to the night before Father's Day of 2019 at Haynesville Correctional Center. A bad batch of dope came into the facility and 8 people overdosed within 20 minutes of each other, and all of the wrong things were done. People tried to dump buckets of water on the person. They put them in their bunks, hoped that they would sleep it off because the incentive was to not report it. One of the primary problems that we have with the overdoses in the prisons right now is that, one, there's not enough staff and people aren't reporting these overdoses. The people that know that overdoses are happening are the people that are incarcerated, and we are scared to report those overdoses because we know we're going to lose our housing assignment, our job, any opportunity that we have. We're probably going to be in segregation for months, even if we had nothing to do with it. I had nothing to do with it. I go and report that my cellmate's overdosing. I'm going to segregation for months. So my incentive is, it's not leverage. My incentive is don't say anything. Hope he sleeps it off. And I'll point to, we talk about leverage and being able to leverage where, how are we sourcing these drugs and how are the drugs coming into the facilities. And we can certainly debate what the sources are, but you can't leverage a person who's dead. We need to keep people alive. And if we want to get information from them afterwards, that's fine. But there's no incentive to keep people alive right now. So I ask that you report the bill and help protect people that are incarcerated in our jails and prisons right now. Thank you.
All right, 240 to go.
Good afternoon. My name is Chuck Mayer. I'm the Deputy Policy Director for Julian, a civil and human rights organization. I echo the comments of my colleagues. I'd just like to say this bill is going to save lives, period, full stop. That's the beginning and the end of it. It's simply wrong to operate a system where people are afraid to seek life-saving care for themselves and their friends. We need to work to address the flow of drugs within our correctional facilities, but we need primarily to work to keep people alive because it is the state's obligation to provide for the care and the well-being of people who are under incarceration. So I urge the committee to report the bill. Thank you for your time.
Fatima, you can go ahead and unmute.
Thank you. I'd like to read a brief statement from my husband who's currently incarcerated at Greensville Correctional Center.
Okay, you got 1 minute, 50 seconds. Go ahead.
My name is Tyler Mawahid, and I'm begging for the passing of the Safe Harbor legislation. This bill will save lives. As a peer mentor in the intensive substance abuse program, I've listened to story after story from these prisoners and addicts in crisis wanting and needing help, but they were afraid of suffering the consequences of self-reporting their substance abuse, which in many cases led to their eventual overdose. I watched as inmates took matters into their own hands, trying to help someone by packing them in ice, putting them in their own bed, and hoping for the best, rather than reporting them to staff out of fear of being penalized as a bystander. Every minute counts in these situations. Every life counts. Help save lives by passing safe harbor legislation. Thank you.
Thank you, and thank you for being quick. Anybody else in line?
Mr. Chair.
That's it. Hold on.
Oh, sorry.
Anybody else in support?
Mr. Chair, there's no one else online.
Okay, we'll close testimony. Delegate Seabold,
Oh,
you get to wrap up.
I have one more quote that's in support of it, but it's a sheriff who wanted to remain anonymous because the Sheriff Association was opposing. But he wrote to me to tell the committee, I believe in this bill because I'd rather save a life and know about somebody overdosing than possibly lose criminal prosecution on somebody who brought it in.
Mr. Chair,
Senator Boysko.
I move to report.
And let's see, this one does not need to go to finance. All right, so any further discussion? Nope. Doesn't create a new crime. All right, so clerk will open the roll. Reporting.
Ayes 9, no 6.
The report's 9-6. Delegate Seabold.
Thank you, Mr. Chair. Thank you, members of the committee.
All right, next up, I've got Rasul, who's still in the probes, and Cherry. Labor trafficking. Are you for or against it?
I think we would be against that, sir, since that's modern-day slavery. But we're going to take up House Bill 633 for your pleasure.
All right.
Mr. Chair, Virginia has made significant advances in the fight against human trafficking, what we call modern-day slavery. These efforts have traditionally been a bipartisan support, and those efforts have focused significantly here in Virginia on sex trafficking primarily. But around 40% of all human trafficking falls under labor trafficking category, and currently Virginia is the only state that does not have a standalone labor trafficking statute. House Bill 633 copies from existing federal statutes and brings the federal statute down to the state level. Without state statute, law enforcement hand over suspected cases to the federal prosecutors, and as we know, justice moves slower at the federal level. I've been working with the UVA Law Center for Local Policy and Government on this bill, and would love to have one of my colleagues that worked with me on the bill to help present the rest of the bill, if that's okay.
Delegate Chair, here's the question I have, which Council also raised, which is that the United States Supreme Court rejected the use of a reasonable person standard in a criminal statute back in 1917, and that's why we never really see a reasonable person standard used in our criminal statutes, because it's so incapable of being precisely defined. And you're not a lawyer, right?
No, sir.
Okay. You probably don't want to answer
You're speaking
that.
English just then?
Yeah.
I'm not real sure.
Yeah, and so you probably don't know what the void for vagueness doctrine is or all that. All right, so.
But I have a phone a friend. I've got my Commonwealth attorney from Chesterfield County, and as well as I know I've been working with your attorney to flesh this out and see if we can find peace on
that's
this.
something on my mind is whether it is even constitutional to employ a reasonable person standard in a criminal statute, which we have typically avoided in this committee since in the 5 years I've been on it. So when your people come up, maybe they can address that. Okay. And I know there's a couple other concerns Council raised about this we're probably going to get into at some point. So why don't we go to support and opposed? Why don't we set it at 5 and 5?
If there's anyone online that would like to speak in favor, raise your hand.
Good afternoon, Mr. Chair. Brandon Robleski, Senior Assistant Attorney General. The AG supports this bill. As the patron mentioned, we're the only state with no labor trafficking law.
There's no what?
We're the only state with no standalone labor trafficking law. This does mirror the federal code, which I would be glad to answer any questions about a reasonable person standard. I see it knowingly in the statute, but if there are individual lines, I'd be glad to address that. There's 14,000 to 17,000 people trafficked into the United States a year for forced labor. I certainly understand that there are abductive and extortive elements at many places along the labor trafficking and forced labor tree, but they're not always continuous, such that an abduction or an extortion prosecution can be sustained. And there's many non-abductive and non-extortive elements to labor trafficking, like threatened separation from your family, threatened withholding of food, threatened injury to another family member of yours, which could not sustain an extortion or an abduction prosecution. The feeling of being forced to live in inferior living conditions. These are elements of labor trafficking that are not addressed by our current, on point by our current abduction and extortion statutes. I would also note that House Bill 581, which is on this committee's docket and will come before the committee, is a multidisciplinary task force bill carried by Delegate Simons, and that bill directs labor union representatives to come to the table with Commonwealth attorneys and other stakeholders in the community to form a labor trafficking task force. So they're going to identify and implement standards for what constitutes labor trafficking and how to address labor trafficking. So this statute would give that new task force, should it be passed into law, and it passed the House unanimously, 99-0, this bill would give the task force the definition of labor trafficking off of which they would then base their standards. So I think the bill is constitutional and reasonable as written, and the Attorney General would encourage the committee to report it.
Mr. Chairman.
Mr. Robleski, how does a regular old jury ascertain what a reasonable person of the same background and in the same circumstances would ascertain? I mean, how does that just not give a complete license to the jury to make it up?
I apologize, Mr. Chair. Can you direct me to a line where you're looking?
Somewhere between 109 and 119 in the memo I got.
Mr. Chair, it's on line 118. It's in the definition of serious harm is where it appears.
mean, how is a jury supposed to figure that out?
It's definitely a question, Mr. Chair, it's definitely a question of fact. I don't think it's vague in these circumstances. It's not been struck down as vague by the federal courts.
Okay, well,
that I'm
hold
aware
on.
of.
Can you agree with me that the words reasonable person only appears in Title 18.2 once?
I have heard you say that before, Mr. Chair. Yes, indeed.
All right, well, unless our computers are wrong, that's correct.
I agree.
And so I'm just not clear how a jury is supposed to figure that out. The reason we don't use reasonable person standards is because it just allows a jury to just make it up. So how does this give enough guideposts to a jury to figure out most jurors are not in these situations. And so how do you have a juror put themselves in the shoes of a worker who's a reasonable person of the same background and circumstances of whatever this position of employment is?
Mr. Chair, I think it's going to depend heavily on the facts of the case, the nature of the labor that is involved, the other circumstances that are being brought to bear, including threats of withholding of housing, food, contact with family, things like that. It's going to be a sliding scale, so I can't give you a definite answer, but I think it's reasonable, and I definitely think it's constitutional, and it's not vague under...
Okay. I think Carol Foy has a question for you also.
Yes, thank you, Mr. Chair. Quick question. In 18.2-47, subsection B, in the abduction and kidnapping code section, it specifically mentions a lot of the language that you have in your bill, and it actually, or in the patron's bill, and it actually talks about with the intent to subject him to forced labor or services shall be deemed guilty of abduction. So why do we need this bill when it's already covered in another subsection?
Thank you, Mr. Chair. Senator Carol Foy, I think much labor trafficking occurs without the required seizure, taking, transporting, or detaining that's forcible in the abduction statute. So as I mentioned, there are definitely abductive elements of many labor trafficking cases that would satisfy the abduction statute, but there are other non-abductive, non-forcible means, and I think Madam Commonwealth's attorney from Chesterfield had a case on point. If you would like to hear an example, I think that would be pertinent for a non-abductive labor trafficking case that was unable to be prosecuted because we don't have adequate coverage in the existing law.
Good afternoon. I'm Erin Barr with the Chesterfield Commonwealth Attorney's Office. I did in 2016, I did have a case that I prosecuted. I've been a prosecutor for 14 years. Chesterfield police came across a woman that was being held in the Midlothian area of Chesterfield County, residential area, nice, high-income neighborhood. She had been forced into an arranged marriage in another country and brought to Chesterfield to live with her in-laws. It was an extended family that lived in the household with her. Chesterfield police came across her, were able to interview her with the help of a family member who came from the other country to find their family member and figure out she had been held there for 12 years. A lot of the forced servitude was at the hands. She had had 4 children. They threatened to separate her from her children. They withheld food from her. Early on in those 12 years, there was physical abuse that they had used to create a dynamic of abuse that forced her into this situation. But we faced the issue that I believe Delegate Cherry is trying to address, is that we did not have a state law that encompassed the situation that we found her in. And in fact, that case was successfully prosecuted federally last year in 2023, and those family members were convicted for the abuse that they perpetrated on her. But we were unable to do so back in 2016, 2017, when we had the situation in front of us. It went on for 7 years. They were prosecuted under the federal forced labor code, which uses the exact language, maybe not exact, but very similar language that is used here, as well as in a number of other state statutes that address labor trafficking. So that's been my experience, is there will be situations where maybe the abduction or the extortion statute don't encompass exactly what we're seeing, but certainly it's malicious, it's horrendous, and it's abusive.
All right. Let's keep the timer going. You have 50 seconds left. UVA Law.
Great. Good afternoon, Mr. Chairman and members of the committee. My name is Gabriel Mahoney, and I'm a student in the State and Local Government Policy Clinic at the University of Virginia School of Law. Views I express today are my own. I would like to highlight a few important other things that HB 633 does to change Virginia law. One thing that hasn't been mentioned so far is that HB 633 is along with establishing penalties that mirror those already in the code for sex trafficking. It's making several other amendments to align the enforcement of labor trafficking with sex trafficking. Additionally, with this comprehensive statute, HB 633 gives local Commonwealth attorneys the autonomy to bring these cases to trial on their own. As was previously mentioned, currently these cases must be referred to federal prosecutors.
You can wrap it up.
Well, for these reasons and those offered before me, we ask that you support this bill. Thank you.
Okay, Senator Deeds.
Mr. Chair, I'd like to know from Mr. Mahoney, the law student, how do you reconcile the reasonable man standard contained in line 118 with existing Supreme Court jurisprudence?
Sorry, let me flip to line 118. I guess in my opinion as a law student, I think it's a fact-dependent inquiry, and I think there are a lot of specific facts of these cases that need to be taken into account based on what kind of labor is being done and also the threats or types of harm that are being inflicted or threatened. And I think that there is circuit court precedent that kind of looks at that line of what is reasonable and what isn't. And I think that because this is built on the federal statute, there is a lot of existing case law that Virginia lawyers and judges can look to when trying to figure that out.
Mr. Chair. I would ask Mr. Benjamin, head of the criminal defense lawyers, the national head, to tell us, is the reasonable man standard stand up? I mean,
Or is this some crazy Servo theory?
Mr. Chairman, the answer is no, but it's more complex than that. When we speak of the reasonable man standard, what they're doing is imposing correctly an objective state of mind. But then the problem with the bill is that it then negates that objective standard by clarifying that it's not only the reasonable person, but the reasonable person of the same background and in the same circumstances, whatever that means. So it remains imprecise.
Got it.
The other concern for the bill, I hear the gentleman when he speaks about there having been no finding of unconstitutionality, at least at the federal level. The problem that we're seeing more and more these days is that we don't know whether a federal statute is constitutional until the Supreme Court tells us. The best example of which
Governor McDonnell
is Governor McDonnell. And now we understand that the Supreme Court will be considering one of the congressional laws that is pivotal to the January 6th prosecutions. And so when you look at the wording, and no criticism of the patron or the folks who have helped him, because this wording is lifted directly from the congressional statute, but that's why it's so poorly written.
Thank you, Mr. Benjamin. Okay. Is there anybody?
Mr. Chair, we have one person that would like to speak in favor.
Okay. But we're okay. The person in favor needs to state your name and say you're in favor. We're out of time on favor.
Patrick, you can go ahead and unmute.
Mr. Chair, Patrick McKenna, Virginia Coalition Against Human Trafficking. We are in support of this legislation. We find ourselves in the same place we were in 2015 when we were the last state to have a standalone sex trafficking bill. I would urge the committee to support this bill. Thank you.
Yeah. Okay. Okay. We haven't done an opposition yet, right? Okay, let's go to opposition.
If there's anyone online that would like to speak in opposition, raise your hand.
Okay, Delegate Cherry, you get the last word.
Mr. Chairman, thank you for the robust discussion today. This was intended to very much mirror the sex trafficking laws that are on the books in Virginia. If we've missed the mark on that, I understand, but I'd love the opportunity to continue to work on this. Moving forward, I think this would be referred to finance and would love to continue to work on the language if we can get to peace in the valley.
Okay, thank you. Thank you, Delegate.
Mr. Chairman.
Senator Stewart.
I'm just curious if the committee is concerned with the word reasonable on 118, why don't we take the word reasonable out? It makes it a tougher case to try, but at least you've got something to try when we're trying to stop these sex traffickers.
Senator, so all I will say to you is that would help. But I think council also expressed concern with 2, 3, and 4 in the Romanettes on 122 to 125, as that sort of broadens things way up.
Well, let's work on it.
And yeah, I mean, and also just this is a common theme we've seen from the Attorney General's office, is pushing bills that just sort of codify federal law to expand our local prosecutors' ability to prosecute things at state level, which the feds already cover. And so I'm not clear why we have to adopt everything the feds want to do, but that seems to be a trend out of this office. And the feds don't always get it right. They don't look at bills as carefully as we do. Oh, I'm sorry. Carol Foy, you in the queue? Still? Mistake? Okay, Bagby.
Oh, no, they just made a motion, so I'm going to be quiet.
Okay, so there was a motion down there?
I was curious if anybody was interested in the amendment.
Yeah, it makes it better, but not great. I don't know. Okay, Peak moves, Jordan seconds.
Mr. Chairman, if there's a way we can work at this, because some of these local prosecutors are telling me they need this tool. I'm less concerned about the federal government and all that stuff. But if they need a tool to do something, I think we need to get
Senator
it.
Stewart, you want to take a week to go try and do some
Mr.
surgery?
Chairman, I can make suggestions now because I do.
No, we're not doing that.
Mr.
We got. I have to be somewhere. He has to be somewhere.
And I want to be somewhere.
Yeah. So.
You get with him. Mr. Benjamin will get with him and try to work through
Okay.
some
Bye for the
changes.
week. Got it.
Yes, sir.
When's the deadline? Okay. So we have to be back Monday.
Yes, sir.
8 a.m.
Thank you, sir.
Sharp. All right. Okay. Without objection, Bill's bye for the day. All right. Next up, I've got Hodges.
You're going to do it, then I'll go.
You gonna? Okay. Oh, Russell made it? Okay.
Mr. Chairman,
Are you still needed?
hopefully
Is
we'll
the
be
probe's
quick.
done? Hold on, Delegate Hodges. Is the probe's done?
Yeah, probe's
Okay.
done. Yeah, we're done.
You're next. I appreciate that.
Yeah, we can do better.
All right, Hodges.
All right, House Bill 1434, request to either be carry over or stricken, Mr. Chairman.
Sorry, say it again?
Either to carry that over or to strike it, whichever.
Okay, Senator Stewart moves.
Mr.
No, he
Chairman,
doesn't.
this is something that the delegate brought that I think needs to be thought out a little better.
It does.
It creates a number of problems and difficulties for the locality and others, and so I would move we carry the bill over to
Okay, been moved and seconded.
2025.
The bill be Stewart and Bagby to be carried over. Clerk will open the roll. All right, bill's carried over.
Ayes 15, no zero.
All right, thank you, Mr. Chairman. House Bill 1187 is companion to Senator Pillion's Senate Bill 16.
I think we already did that.
614. You already did that?
I think so.
Yeah, we're good then.
We just carried over 1434. But his other one, we already did the other one.
Salazine, you've already taken care of?
Yeah, you're done.
Good, thank you.
All right, Rasul has keep calling his name, but he's stuck in committee. Delegate Rasul has a substitute. Senator Bagby moves. Aird seconds, a substitute. All those in favor of substitute, say aye. Aye. Anybody opposed? No. Substitute is now before us. And I believe, has that already been distributed in the packet? Okay. Delegate Rasul, explain to us how your substitute is different from Senator Aird's bill, which got sent back to committee and never heard from again.
Thank you, Mr. Chair, members of the committee. There are significant differences, but let me just tell you about this much smaller bill. What this does, Mr. Chairman, is to put in process for certain felonies that there be an automatic expungement at the age of 29 for a juvenile who's committed those felonies. I know that there were a variety of other pieces that you may have discussed with Senator Aird's bill, but here, just by the age of 29, there's an automatic expungement. The substitute that is before you does a couple of things that I want to highlight. What we did in talking with some members of the committee is we took out just the few exclusions and put a list in. And we also added a section about an offense for which a juvenile is required to register under the sex offender registry, and to make it more palatable for some members of the committee. I will say, Mr. Chair, that courts have just made a request, and there has been conversation with the Commonwealth Attorney to take the list and actually list those things out so it's easier for them in their computer system. And they have come to the conclusion, they've agreed on a list. So I'll let them talk about it. But right now, 19.2-297.1 creates a problem, and I'll let them speak to it, creates a problem in their computer system. And what they asked is, can you simply list them all out?
Okay, so all you want to do is just list a whole bunch of crimes instead of...
That's correct.
You know what that'll cost taxpayers in paper and ink? Oh, my God.
Mr. Chair, I move that amendment.
Senator Aird moves and Bagby seconds your amendment. All those in favor of the amendment say aye. Aye, okay, you're amended. Okay. Now, basically, your bill does is the same thing that Senator Aird's bill did, except it narrows it down, or it excludes from the bill the ability to expunge violent felonies and other felonies that are sex offender listed on the sex offender registry, right?
Pretty much, yes.
It's narrower than the bill we passed earlier out of this committee.
Yes, sir. And it would be open records until the age of 29.
And we already heard this entire bill before. We took a full hearing on this with Senator Aird's bill, right?
Correct.
Okay. Does anybody have any concerns about the bill that they didn't state before because of the amendments that Delegate Rasul has made? OES?
I spoke briefly. Eileen Longenecker with OES at the Supreme Court. I spoke briefly with Delegate Rasul when I learned there was a substitute. In looking at it now, I'm not sure, and I'm just raising it because I don't know, whether our system is going to know what felonies require registration for the sex offender registry. And so I can look into that, and I will get back to you on that, Delegate Rasul, but I'm not sure if we know that. The expungement here, currently all felony delinquency are retained under current law. So going back to the 90s, these felony delinquency cases would have to be expunged,
right.
And through programming, we'll have to determine which...
Sounds like a finance problem, right?
Perhaps.
Right? But in terms of the policy... You all are just worried about implementation, but not...
Exactly.
Yeah, okay. That sounds like a finance problem more than anything. Okay.
Mr. Chair.
Senator, who is that?
It's me.
Taylor.
I just want to clarify, and maybe Eileen, the offenses that we're now listing out are, for now, the amendment is just to list out the offenses included in act of violence in 19.2, rather than cross-referencing it.
Correct.
Yeah.
Correct.
Right.
I just don't know. I'm just seeing the sex offender registry part here for the first time, and so I just don't know
Okay,
about
and Senator Perry's light's green. Not anymore. Okay. Okay. Anybody else have any concerns with the bill now, with the amendments that we've made to the bill? Doesn't look like it. Anybody online? Nope. Okay. Are we ready to send this smaller bill out to finance? Okay, it's been moved by Senator Aird and seconded by Bagby that we report and re-refer the bill to finance. All those in favor? Clerk, open the roll.
Ayes 10, noes 5.
All right. Next up, that's it.
Thank you, Mr.
For you,
Chair.
right? Yep. Okay, next up, I have Green. What? Oh, Green did not need to sign up. Cognate. Gardner. And somebody needs to tell Watts she needs to get here. Huh? I know, I'm supposed to be in her committee. Okay, Gardner, you've got 1369. You've been waiting extremely patiently.
Thank you, Mr. Chair.
And is this your first time in Senate courts?
Yes, it is.
All right, what's your favorite food?
Italian sausage.
Nice. She had it ready. Okay.
I did. I've waited long enough to figure it out.
All right, tell us about your bill.
Okay, so 1369 just changes one word in this code from universal to model. And what this does is provide that an approved criminal justice training academy may utilize an alternative model curriculum and lesson plans that meet or exceeds the compulsory minimum training standards without seeking a waiver from the Department of Criminal Justice Services. Under the current law, the department is required to develop a uniform curriculum to be used at all criminal justice academies unless a waiver to the uniform curriculum is granted by DCJS. And this bill was brought to me by the State Police Association, and I have Mr. Carrico here to answer any questions. There's also people from DCJS as well.
Okay. DCJS is cool with this bill?
Yes, we made the recommended amendments that they asked us to.
Okay, it's been moved and seconded. The bill be reported. Doesn't look like anybody's opposed to it. Clerk will open the roll.
Ayes 15, no zero.
Yes, thank you.
I'm sorry you had to wait so long for that.
No worries.
Next up, I have Delegate Anthony. And Anthony, you've got 1435, a cleanup bill, Boyd Graves from last year on subpoenas, which we had a lot of discussion about and consternation about before we finally passed.
Thank you, Mr. Chairman. It's French fries.
This is your first time. Good one. Pays the chair some. All right.
HB 1435, as you described, is a recommendation from Boyd Graves. It expands the provisions for releasing a witness from just an attorney-issued subpoena to a subpoena issued at the request of a party or at the request of an attorney representing a party. Hopefully, be will of the committee to report.
Okay, so this, I guess.
Mr. Chair.
Senator Jordan.
Mr. Chair, I want to ask the patron, what did it pass the House out of by?
Excuse me, repeat that question.
By what
Mr.
vote
Chairman?
did it pass through the House by?
I believe it was uncontested.
I've got it 99 to 0.
Yeah.
Follow-up question, Mr. Chair?
Huh?
Follow-up question?
Go ahead.
I just would ask the patron, is anyone opposing your bill?
No.
Move to report.
No, all the lawyers had a big argument about this last year, and we had a big, long lawyer fight. Oh. Okay. Jordan moves to report. Aired seconds. If Peterson was only here to see this, he'd be crying right now. Right, I remember, yeah. Okay. Okay, clerk will open the roll. Yeah, he and I fought it.
Ayes 15, no zero.
Thank you.
Okay, the only thing we have left is 2 Watts bills. Anybody know what's up with her?
We have Davis.
Oh, Davis, he's back? Oh, you've got your language figured out?
Mr. Chair, I would request, if I may, that this be continued to the next meeting so we can have time to work with council and try to clear up the language.
Okay, and save us some time next time. That's fine. So without objection, the bill will go by for the day. Now, what about, thank you, Delegate.
Thank you.
What about Watts? Okay, without objection, Watts will go by for the day, and now I'm going to go present to her. And that completes our docket.
Senate of Virginia, Richmond, Virginia.